Good morning, everybody, and welcome to the third in our series of webinars for Safe Work Month 2021. This morning, the topic for you is the Work Health and Safety Mines Regulations 2021, and it is your opportunity to ask questions, so I hope that we're going to be able to provide some answers for you as we proceed through. Today, we've got a couple of individuals to present to you and provide answers as we go along. Anil Attri is a mining engineer with a Bachelor of Engineering in Mining and a Master of Science in Geotechnical Engineering. He's got almost 50 years work experience in or with the mining industry in Australia, the US, Zambia, India, and Anil is currently assisting in the development of the Work Health and Safety Mines Regulations. So the key person to answer your questions in relation to this set of regulations. Assisting Anil this morning, we've got Sally North, and Sally is currently the Acting Director of Mine Safety. She's got qualifications in chemistry, occupational safety and health, business administration and occupational hygiene. Sally's worked in operational areas of safety regulation since 2001 in inspectorate and leadership roles. And as I said, she's currently the Acting Director of Mine Safety. Just before we get underway, the department would just like to acknowledge Aboriginal and Torres Strait Islander as the people, as the traditional owners of the land on which we deliver our services, and we pay our respects to their elders and leaders past, present and emerging. And we say hello to everybody throughout the state of Western Australia who's tuning in this morning. As I said, this is an opportunity for you to ask questions, so we will commence with Anil doing a short presentation, but then we'll throw it over to you. The way that you engage this morning, and you would have seen the slide in the lead up, is via Slido. Please don't submit your questions via GoToWebinar because we won't see those. But without further ado, I will hand over to Anil and he'll get us underway.
Thanks, Andrew. I'm Anil. As Andrew said, it's basically a question and answer session, but I'll give you a very brief description of how the proposed legislation is structured and it will function. As you know, the Work Health and Safety Act of Western Australia was passed by the Parliament last year. The Act will be supported by 3 sets of regulations, and we are today concentrating on Work Health and Safety Mines Regulations. In addition to that, the other 2 regulations will be Work Health and Safety General Regulations and Work Health and Safety Petroleum and Geothermal Energy Operations. It is important that we understand that these 3 regulations are stand-alone regulations. Their jurisdictions are different. So where a particular set of regulations apply, the other 2 regulations will not apply. In addition to that, the Dangerous Goods Safety Act will continue to apply to mines as it has been applying earlier. Now about the jurisdiction, as I said, these regulations will apply to the mining industry, and the jurisdiction will be governed by the definition of the term mining operations. This term will not change from what it is in the Mine Safety and Inspection Act, except for a minor change. As you know, that in the definition of mining operations in the MSIA, there are inclusions and exclusions. We will exclude the public ports, and that's the only change we'll have. So the proposed regulations will apply to all the mines they currently apply, and that includes exploration activities as well. Now a little bit about the general regulations. The model regulations were prepared by Safe Work Australia, and they will apply to the general industry. But because mines regulations will be stand-alone regulations, so all those regulations which are in the model regulations of 2019 will be included in the mines regulations with very few changes. Because we are harmonizing with other jurisdictions, the numbering of the regulations will remain the same, and all additional regulations will be having numbers in alphanumeric forms. In addition to that, because some topics will be covered in the mines chapter, which will be chapter 10 of these regulations, and these topics are covered in general regulations as well. There will always be a cross-reference in the mines chapter so that any reader knows the whole picture. Sorry, I can't move it. Yeah. Now, from the general regulations, there are few approvals or registrations required. These are like high-risk work license, asbestos removalist license, demolition work license, registration of classified plant, general construction induction training. Now, it is decided not to replicate these regulations in the mines regulations, but there will be a requirement that these registrations or certifications are required, and they can be obtained under the general regulations. Now, about the mining specific regulations, Chapter 10 will have all the regulations that will apply to mines, in addition to all other chapters which will come from the general regulations. The basic change you would notice from Chapter 10 is that all the duties are of mine operators, whereas in other chapters the duty is of PCBU, person controlling business or undertaking. Mines regulations are heavily dependent on risk management of hazards and their associated risk, and that is why a lot of prescriptive regulations which are currently in the mine safety and inspections regulations will be removed. As you can see from the slide here, currently in Chapter 8 we have about 57 regulations on explosives. In the proposed regulations, we'll have only one regulation on explosives. The other one is the contaminants and ventilation. Currently, we have 37. 2 will be in the general regulations and 21 in the mines, and that will cover including use of diesel equipment in underground. Underground mining, we have 60. They will be reduced to 3. Winding systems, we have 89. These will be reduced again to 3. Shaft sinking, we have 19 regulations in MSIR, and we'll have only one notification to be given to the regulator about shaft sinking. Surface operations, 15 will come down to 1, and dredging, we have 9 regulations. That will be replaced by 1 notification to the regulator. The single most important change and the requirement for the mine operator in the proposed regulations is to prepare, implement, and maintain a mine safety management system. Because it's a new requirement, there will be a transition period for the development, 1 year, and for implementation, another 1 year. This is the document where the mine operator will establish its policies and what the mine operator wants to achieve in the area of health and safety. And this document must remain effective and reflect the current operations. There will be requirements to update this document as well as audit the performance based on this document. The mine safety management system is again heavily based on risk management. Out of this process, there will be procedures, plans, and systems. Then there is a requirement of management and supervisory structure. Many people have asked me a question about Section 44, where a principal employer has to establish, or the registered manager has to appoint certain people to assist in the implementation of Mine Safety Inspection Act. That provision will be replaced by this requirement for the mine operator to have a management and a supervisory structure. Then induction, information, and training. There is an equivalent provision in the general regulations also, but between the two, this places additional duty on the mine operator. Resources allocation and how contractors will be managed if work is being done at a mine site by a contractor. The key documents or plans which will be covered by the mine safety management system are Principal Mining Hazard Management Plan. The term Principal Mining Hazard has been defined in the regulations, and how associated risks are to be managed will be documented in these documents. Emergency plan, this is a requirement in the general regulations as well, but mine-specific emergency plan additional requirements are given, will be given in this particular document. Health management plan, this is like currently we have health and hygiene management plan. This document is very similar to that, but will replace health and hygiene management plan. Radiation management plan, there is no change. Currently also we have a radiation management plan, and that will be replaced by the same radiation management plan. And underground ventilation plan, there is no change there as well. One more change which I must bring to your attention is currently there are certain approvals which you need to have obtained from the state mining engineer. The first one being when you start a mining operation under Section 42 of MSIA, a notice of commencement must be given, and approval from the state mining engineer must be obtained. That will be replaced by simple notification. Similarly, for winders, you need an approval. For sinking a shaft, you need an approval. And for starting dredging operations, you need an approval. All these approvals will be changed to notifications only. However, radiation management plan will need a requirement of approval from the regulator. So in conclusion, three things important. Mine safety management system is a new requirement. Second, lot of prescriptions because of my introduction of mine safety management system. Lot of prescription from the regulations will be removed, and quite a few approvals currently that these are given by the state mining engineer will be replaced by notifications. We'll move on to the question and answer session now. And Sally will join me and help me out there.
Thanks very much, Anil. And firstly, just to let everybody know that this webinar is being recorded and it will be available on the WorkSafe website at a future date. So the first question that's come through for us is, can you clarify the difference between PCBU and mine operator? Yes.
Currently under the Mine Safety Inspection Act, people know that there is a term called employer and a principal employer. The proposed legislation is trying to move away from the term employer because establishing the relationship between an employer and employee has been a problem. So the employer term is being replaced by PCBU, and the principal employer will be replaced by mine operator. And the definition of mine operator will be very similar to what it is in the Mine Safety and Inspection Act under Section 32 and 4, Section 4.
No, thank you. We've also got a question on regulatory appointments for mining. Can you clarify what they are, and will the list be reducing from the current regulations?
Yes, Mine Safety and Inspection Act is quite prescriptive. The way the registered manager, quarry manager, underground manager, they are appointed, and then their alternates are to be notified to the department, to the district inspector, and even deputies. When both are not available, then deputies need to be reported. We are moving away from a lot of administrative functions which are under the Mine Safety and Inspection Act. There will be, as I said, in the mine safety management system, there will be a management and a supervisory structure. It is the mine operator who will appoint these people under that. But the position of registered manager will still remain and will be called site senior executive. Underground manager, yes, we will have. Quarry manager as well. These positions will be in the management structure maintained by the mine operator, and not only their appointments, but when they are not available, who would do that job, that will be part of the mine safety management system. So yes, it is correct that a lot of notifications which are currently being given to the department will be reduced. Site senior executive will have to be reported to the department, but others, no, not necessarily.
Okay, so it sounds like there's going to be less need to notify, but there's still a need for the mine to be having a system in place for those.
Yeah, I mean the structure, the management structure has to be there. The mines have to be managed and managed properly, but whether the regulator should know everything, that's where we are making changes. Yeah.
Okay. All right. How does the statutory function of supervisor differ compared with a supervisor appointed under Section 44 of the MSIA?
Yeah, I think it's a good question because statutory supervisor is a new position. It's a statutory position. Currently, as we know, that supervision has to be provided, and MSIR tells you for certain, say, underground or for certain areas, how often this supervision must be provided. What we are doing is statutory supervisors are required for certain areas like underground, quarry operations, workshops, process facilities and labs, plus any other area if the mine operator decides because of hazards and associated risk that a statutory supervisor must be appointed, then mine operator can make that decision. But for the areas I just mentioned, these must be inspected by a statutory supervisor. Because it's a statutory position, there will be certain requirements who can be a statutory supervisor. A person must have at least 2 years of experience in the industry, must pass a law examination, and by the way, these law examinations will be all computer based, and the results will be known then and there. Plus, they will have competencies in risk management.
Yes, it sounds like there's a few innovations happening in that space.
Yeah.
Will a workshop fitter providing oversight, including supervision, and allocating tasks to an apprentice be considered a supervisor in that way?
So the statutory supervisor is supposed to be the front line supervisor rather than their superintendent and their manager. And what was the second part of the question?
That was about a workshop fitter, whether the fitter would be considered a supervisor, a statutory supervisor, I gather.
The term statutory supervisor is defined, and it is the person who allocates tasks and supervises tasks. And as I just mentioned, it's not like if there are 3 supervisors, all 3 will fall in that category. No, it is the frontline supervisor who will be considered as statutory supervisor. Yeah.
Okay, and is there a transition period available for all statutory roles?
Yes, there will be a transition period of 3 years, particularly where there are additional requirements. Because we are introducing a requirement of competencies in the risk management, we will have a transition period of 3 years, and this has been decided with extensive consultation with the industry. Yeah.
Okay, so that's time to let everybody get up to speed with the extra training that may be required.
What will happen, like today, there are people who have a, say, first-class mine manager certificate or a quarry manager certificate. They will be allowed to operate under their current certificates up to 3 years. Then they will have to meet the additional requirements, and which is basically risk management competencies for these people, or a law exam within those 3 years.
Thank you. The next one's about the mine's record book. Is it now up to the mine operator or the PCBU to determine how this can be captured, and can the mine's record book be electronic?
Yeah, I think our present legislation is slightly outdated, because it says mine record book is a book as the state mining engineer defines, and state mining engineer stated it has to be an A4 bound numbered page. I don't think in current environment it works very well. Most of the records are in electronic form, and yes, electronic documentation will be allowed under the new legislation.
Oh, that's good to hear. The next one I think refers to the regulations, we're speaking of. When will a final draft be available to look at?
We are in the final stages of drafting. Hopefully by mid-November we will have the first draft, and the government is interested that it is gazetted around that time.
So gazetted in November, hopefully.
Yeah.
Yeah. I'm sure a lot of people are looking forward to that. Section 290 regulations include repairs and maintenance activities as construction work. Does this include mining shutdowns, which often have 5 PCBUs on one plant?
Yeah. Construction work is defined as in the regulations, and it generally applies to structures. But yes, as the questionnaire has mentioned, there is a specific case where a plant, and if more than 5 PCBUs are working during a shutdown, then that is to be taken as construction work. And yes, that will be covered as treated as construction work. Yeah.
Okay. We've got one on mine safety management systems now and record books combined. Does the mine safety management system replace a mine's record book?
No, the two concepts are very different. A mine safety management system is the primary tool which a mine operator will develop. It lays down its health and safety policy. It tells what I'm trying to achieve in the area of health and safety, how it is integrated with other systems in the mines, how we are going to manage contractors, if there are contractors, how we're going to manage training, how we're going to have the supervisory and the managerial structure, as I said. And it's a live document where, based on the hazards at a mine and the risk assessment done for those hazards, what controls the mine operator will put in place to ensure that workers are safe and healthy. That's a working document to achieve the results which we want to achieve. Whereas a mine record book today and in the proposed legislation will be merely a place where certain documents are kept. And what documents should go in the mine record book. Mine record, actually the book word is removed from there because we don't want it to be a book now anymore. It is a mine record. So the records which must go in mine records are listed, yes.
Okay, maybe some examples of the kinds of things that might be in the book? Sorry, not the book, the record.
The inspector goes and he makes a site visit to a mine, and currently, like inspectors make a record of the site visit, they issue improvement notice, they may issue a prohibition notice. So all these and corresponding the actions taken, all those documents need to be in the mine record book.
Yeah, okay, no, that's good. So it sounds like the system is more of the risk management and what's planned to occur, and then the record, not a book anymore, but the record is about some of the key events that do occur.
Yeah, that's right.
Fair? Yep. Another one on mine safety management systems. Are they replacing the safety management plan?
I don't know which safety management plan we're talking about here. There is a safety management plan in the construction industry. That's a very different document to the mine safety management system. Mine safety management system is a document, as I have said, and I need not repeat it. It's the fundamental primary document for the mine operator to achieve higher standards in health and safety. One thing is in the current legislation, not safety management plan, but we have a project management plan.
Okay.
Perhaps the question is about will the mine safety management system replace project management plan? Yes, project management plan is a document which is required under the mine safety and inspection regulations, and that must be submitted to the state mining engineer. And on the basis of the project management plan, the state mining engineer gives an approval for the commencement of mining operation. So project management plan is a one-off document which is prepared before the mining operation commences. Whereas the mine safety management system is a live document. It starts before the mining operation starts, and it continues and remains a live document until the mine is closed.
Thank you. This one ties into that. What are the principal hazard management plans expected to look like? Will a risk assessment accompanied by an explanation of the decision-making framework suffice? So I guess they're saying if you do a risk assessment around one of those hazards and you explain what's done in terms of a control, would that be a principal hazard management plan?
Yeah, the term principal mining hazard is defined anything, and there are quite a few things covered in the definition, which can cause multiple fatalities in a single event or in recurring events. So like ground instability is one, use of winders is another, movement of vehicles is another one, underground fire or explosion is another one. Now, these are the items in the mining industry. These particular events make mining industry more hazardous. We are doing better than what we were doing perhaps 30 years or 40 years ago, but these hazards are still there. an underground explosion, not so in non-coal mine, but in a coal mine, can practically bring an end to that particular mine, as we saw it happen in New Zealand. So these are the events which need very detailed risk assessment and controls to be placed in position. There will be a schedule for the listed principal mining hazards. Those things must be considered in addition to the risk management, and make sure that controls are placed against all those possible things. In addition to that, the definition of principal mining hazard has that the mine operator, because all principal mining hazards cannot be listed in the definition, so it is the responsibility of the mine operator to make an assessment of the mine, and if they have a particular activity, say if they use a large dredge, and if there are many people working on that dredge, and if things go wrong, can it cause multiple fatalities? Then dredging becomes a principal mining hazard for that particular operation. So the mine operators must decide what are their principal mining hazards and develop a management plan.
Okay. And will there be guidance material on the principal hazard management plans?
Yeah, it is the department's intention to have codes or guidelines for most of the important principal mining hazards. We already have, like, ground control is an important aspect in the mining industry. We have a code at the moment. We are reviewing that code, and we are interested in ensuring that it meets the requirements so that people can use it to develop principal mining hazard management plan.
Because essentially we're talking about, in most cases, risks, that are really well understood in the mining sector already, aren't we? And of course there'll be existing controls and existing guidance that will be, to a large extent, transferable.
Yeah, that's right. But every aspect, as I said, all principal mining hazards are not listed. They are not even in the schedule. But the concept how a principal mining hazard management plan must be developed, yes, there will be guidance material so that people understand the process they have to go through to come out with a principal mining hazard management plan which is effective.
Thank you. Now we're back to supervision. What supervisors are required to be statutorily appointed, and will there be further guidance issued on this?
Yes, as I answered earlier, the statutory supervisors, there are areas which is, I will repeat again, that quarry operations, underground operations, process plants, workshops and labs are listed areas where statutory supervision is required. In addition to that, a mine operator can add other areas if the mine operator thinks hazards are significant, to appoint a statutory supervisor. And as I said earlier, the statutory supervisor will need to have 2 years experience in a similar industry, have competencies in risk management, and pass a law examination. Yeah.
Now this next one's got a little bit of a crossover here with the Act. So it's, are all appointed roles considered to be duty holders? And in the second part, can they be prosecuted under industrial manslaughter?
No, this is, it's a complex one. The industrial manslaughter does not apply to every duty holder, and that's why the site senior executive and others are not covered by that particular provision.
Yeah, yeah. So my understanding that is in the Act, and we've got information online in terms of industrial manslaughter and how the Act applies to that. But basically, we're looking at officers who are very, very senior.
So the definition of
Yes.
officer comes from the Corporation Act, and it very clearly states who can be an officer, and this question has been asked whether the site senior executive is an officer of a mine. Generally, a site senior executive will not be, but there may be a case where the member of the board or the owner himself appoints himself as the site senior executive, then that particular person becomes the officer under the Act and will be covered under that provision.
Yes, yes. And I think as a broad level, you know, there's people that have duties under the Act, including workers. Just because you have a duty, it doesn't mean that you're liable for a manslaughter charge. That's a really very niche kind of a charge that's only available in some very specific circumstances, whereas broader duties around looking after your wellbeing and making sure you don't put others at risk, those kind of broader duties that, you know, aren't to the same level as manslaughter, those are more broadly applied in the legislation.
The manslaughter is either it's the PCBU or the officer,
Yes.
not every duty holder.
Yes,
Yeah.
and only in very specific circumstances. So there's a question on gazettal. If gazettal is in November, is the commencement date moving accordingly? For large companies, there is still much work after gazettal to meet the start date.
The start date, as the government has previously said, that the legislation will commence, will be proclaimed early in January, but at the same time, sufficient time has to be given, and that's a decision to be made by the government between the gazettal and the proclamation. What duration will be there? I really don't know. It's a decision by the government. Yeah.
So if it is early in the year, then it's important that, you know, there'll be information provided on the transitional provisions, and, you know, for some of these new provisions, there is some time available for organisations to make some changes to align with the new laws. And a lot of things that they've got in place already will also meet requirements. You know, a lot of, I guess some of the less prescriptive requirements for safe systems will already be in place.
Yeah.
Yeah.
Actually, Part 11 of the regulations will have quite a few transitional provisions, and we are still working on some of these transitional provisions. When a particular thing is a very new requirement, generally there will be a transitional period for the industry to implement that. Yeah.
Okay. How will contractors fit into mine safety management systems, and can contractors have their own mine safety management system?
Yeah, I think there is a specific provision in the regulations which states that a contractor can work at a mine site, and there are two scenarios. One, the mine operator has already covered those aspects, and the mine operator provides all the information to the contractor and say, hey, these are the controls I propose, do you accept these? And if the mine operator says, yeah, that's okay with me, then mine operator can work under that mine safety management system. On the other hand, if it is a very specialized job and the contractor, they understand more than what the mine operator understands, and they have their own safety management system, they can make that available to the mine safety management system, to the mine operator, and if the mine operator accepts that safety management system, then the contractor operates under that safety management system. So both options are available.
That sounds like there's a bit of flexibility available there to see what's going to work best.
Yeah.
Yeah. Okay. All right, the next one is relating to a current exemption. It's will classified plant need to be registered individually like it is in other states, or will the sector still be exempt?
No, we are currently actually making a decision about this particular thing. As you know that the state mining engineer issued a general exemption in the year 2013, and quite a few items of classified plant have not been in the mining industry have not been registered if their design was registered by either WorkSafe or any other WHS jurisdiction. This particular exemption will be withdrawn in a transitional manner, and there will be certain items which will need to be registered within the very first year. These are high hazard items, and a few more in 2 years, and the last bit in 3 years. So the answer is that yes, these classified plants which were covered by the general exemption will need to be registered, and there will be a transition period based on risk associated with these items.
Okay. Will there be industry consultation or a comment period for all three of the sets of regulations?
I think we have gone through this process a number of times. As you know, in 2019, the conceptual regulations and the model regulations and what changes were proposed to the model regulations were made available to the industry, and we got very good feedback during that process, and all those comments have been considered by the government, and those a lot of changes have been incorporated based on that feedback. So I think we have reached a stage where these regulations are more or less final, but it's up to the government. I mean, if there is any further change can be made and is very necessary, the government may make that decision.
Okay, this one probably goes to the level of prescription and how the regs are drafted. What will be the status of Australian standards in the new regulations? And can notices be issued if certain plant is not compliant with an Australian standard?
Generally, the Australian standards, when we harmonized and WHS model regulations were developed by Safe Work Australia, one principle was to remove dependency and mentioning of Australian standards in the regulations. It causes certain issues with some of the classified plant because design of classified plant is heavily dependent on Australian standards. Whether they are mentioned in the regulations or not, it's good information, and these classified plant will continue to be designed as per Australian standards. And when we approve a design or we register an item, that criteria will still be considered.
Yeah, no, that's really good to hear, because I think it's important that, you know, when we're looking at high hazard plant, the safety standards are not going to go backwards.
Yeah.
So we're going to, if we're currently working to an Australian standard, we're going to still want to work to, you know, to an Australian standard, and that gives a baseline for people that are designing and working in industry around what those expectations are for that high hazard plant, and provide some clarity. Now, the regulations are not calling up a lot of standards, but they will be referenced, I believe, in guidance material, and they're certainly part of the state of industry knowledge around this. So I certainly would encourage industry to keep utilising those standards as
of
they
course,
have been.
yes. We can't do away with
No.
Australian standards. There's a wealth of information there.
Absolutely, and you know, this type of plant is you know, is regulated in this way because it can present risks if it's not well done and well designed.
Yeah.
Yeah. Okay. So this is a similar one around standards. So does this mean that we won't have to comply with Australian standards if it's not called up in the regulation or in the mine safety management system? And can we import a presumably plant without having to check compliance?
Yeah, if the engineering standards used by an imported equipment are better or equivalent to the Australian standards, by all means, yes, that's all right.
Yes, and the importer will need to do some due diligence, would
Yes,
they?
exactly. I mean, the question is, because they are following some different standards, we need to do a comparison whether they are as good as our Australian standards are. It's not just because, yeah, it follows ISO or it follows European standard, and we must accept because this is accepted in Europe. It won't be that straightforward. We will still compare whether they meet our minimum requirements, whether they come from Australian standards or from any other standard within Australia.
Yes,
Yeah.
so if an importer is looking at that, it's prudent for them to do a comparison of that type before they're making import decisions.
Yeah, that's right.
Yeah. Okay. Now there's a reference to a recognised health and safety risk management course. What will be the approved content and who will be approved to deliver this?
Yes, these will be approved courses, nationally accredited courses. Under the new regulations, a mining competency advisory committee will be established, and there will be representation from the employers' bodies, from the government, and other experts in that area. And for each statutory position, they will decide which units are most suitable, and once those decisions are made, they will be available on our web page, and then people can go to those RTOs and get those courses done. Yeah.
Thank you. There's a reference to a health and safety legislation exam for statutory functions conducted by the regulator. Would this be outsourced to training providers?
No, it will run, and it will be a computer-based multiple choice type examination. A candidate can pay the fee and come to the department. We provide a computer, and even we are thinking whether external computers can be hooked into the department. So if we run out of computer, we don't have many computers, and then the candidate does the exam, and at the end of the examination, he knows or she knows the result, and a slip or a certificate will be issued then and there that yes, you have completed this particular exam successfully.
So while it's done on a computer, it's also in person, so the person is still
I think
presenting?
we are not allowing people to log in from other parts. We want to make sure the identity of that person, but who knows, with time this may change.
Okay. Here's a question around notifiable incidents. If anyone is sent to Perth for treatment under, as there are no remote treatment options, is it reportable?
The definition of a reportable incident is in the Act, and if a person has to be rushed for an external treatment, I think that's one of the reportable incidents.
Yes,
Yeah.
I agree. I don't recall the exact wording of that one, but there is something along those lines that is
exactly.
notifiable.
Yeah.
So have a look in the Act provisions for that. Yeah. Will verification of competency requirements be changed in the new regulations?
Competency, when you use the word competency, it brings in two things, and I must explain. There are statutory functions, and there are statutory functions which need certification by the department. And then there are statutory functions where competency requirements are given in the legislation, but they don't need a certificate from the department. For quite a few statutory functions, competency in the risk management will be an additional requirement. Currently, it is not. For certain certified functions, we have a first-class mine manager certificate. We'll continue to have that certificate. We have quarry manager certificate and a restricted quarry manager certificate and underground supervisor certificate, authorized mine surveyor grade 1 and authorized mine surveyor grade 2. All these certificates will be maintained. These will need an additional requirement of competency in the risk management, and law exam will be another requirement. Yeah.
And it's talking about verifying competency. So once there's the initial assessment of competency, is there anything down the track for those particular ones to verify?
See, we do not have a continual professional development. That concept has been adopted by New South Wales. We are not having that. If you are declared as competent for the statutory function, at least for as we are proposing, you are competent for life. That's the way it is at the moment. But there is a committee which is trying to harmonize competencies in various jurisdictions in the mining industry, and there is a push that Western Australia should also adopt continuous development part of it. But at the moment, we have decided not to go with that. Yeah.
Okay. This next one's a bit about the Act, but we'll see what we can do with it. So the health and safety advice may be given by an external consultant to the PCBU, and the PCBU may act upon that. If there's then an incident, is the external consultant also culpable?
Yeah, that's the purpose of this particular provision. It's a new provision, and we'll see how it goes. Yes, that there is a responsibility of an external consultant when they make an advice to the PCBU, and if the PCBU uses that advice for the purpose it was given, and things go wrong, then both PCBU and the consultant, they have a responsibility. Yeah.
And that's basically around making sure that the advice an external consultant is providing is fit for service type of advice, which is a requirement already, that advice is appropriate and suitable for the situation. But I think the new Act clarifies that that is a duty. And as you said, there's some provisions around that. And as with any particular incident, the fact that an incident has occurred doesn't necessarily follow that there's been a breach on some party's behalf. Exactly. Investigations are made to assess that and consider whether there was a breach, but the fact of an incident is not necessarily pointing to a breach in all circumstances. So it's a matter for the facts of each matter, but an external consultant that provides advice is a duty holder now under the Act. And
surely that aspect will be looked into when we investigate an accident or an incident. Yeah.
Okay. All right. So obviously case by case, depending on those facts, would obviously have to be a prima facie case for the purposes of the courts if that was to proceed.
Yeah.
And we'll be looking to provide some guidance as a department in relation to that aspect in the near future. So we're looking again at the mines record book. Who's the responsible party for owning or verifying the mines record? I'll leave off the word book. And how will the electronic version be verified or secured to prevent unauthorised use?
Yeah, what we are trying to do here is that the mine record is maintained by the mine operator, and now there are systems available that once you make a record, you can't alter it. In addition to that, we made a commitment to the industry stakeholders that the department should provide an oversight on certain things which go as mine record. So as you know, we have an SRS system. A lot of information goes into it. The mine operators will still have the option of putting that information, what goes in the mine record, in our SRS system. so that the inspectorate or the department can provide an oversight and make sure that the mine records are being maintained the way they should be maintained.
No, very
And because it also includes appointment of statutory position, and that's where we want to keep an eye on it.
Yes. Okay, now look, we only have a few minutes left, but we'll answer as many questions as we can over the next few minutes. All right. Do you think that in early 2022, when the Act comes in, that there might be some reluctance or a slower rate of enforcement as inspectors are in a learning phase with the legislation?
See, whether we are working under the present Act or the proposed legislation, health and safety cannot be compromised, so it remains there. Very new requirements, if equivalent things are being done under the present legislation and there are provisions for transitional arrangements, they can be allowed. But we are not going to be in an area, oh, this is a new act and we don't understand and we don't know what to do. And then that has an adverse effect on health and safety. That cannot be allowed. That's very clear, whether it is the present legislation or the future legislation. Yes, there will be time, as you said, inspectors, industry, everyone will be learning. The department has already taken steps in educating inspectors. Computer modules have been developed, and our inspectors are going through those modules and taking the even exams through those modules. So hopefully most of the inspectors will know what is in the Act. Regulations, yeah, they are not 100% as yet, but from the time the regulations are gazetted and proclaimed, yes, there will be a very quick, fast learning curve for both inspectorate as well as the industry.
And as inspectors are already OSH professionals, professionals in their field, then, hopefully they'll pick up the Act fairly quickly and the regulations, in due course. So I'm sure that will all work out. Any questions that we don't get to, just to let everybody know, any questions we don't get to, we will have regard to. We'll read any questions that have come through and we haven't got time for, and we will look to those as we develop guidance and information for industry. So we will look at all of your questions. Thank you for those. So will there be any grants or discounts on the mine safety levy to help the transition?
I just don't have an answer to that, sorry. It is, as you know, the mine safety levy provisions have not been changed. Mine Safety and Inspection Act has been amended just to keep the levy provisions, and mine safety levy regulations will remain the way they are. The only change we are making in the levy provision is about currently the hours need to be given on a monthly basis. Because we are changing under the WHS mines regulations, returns to be quarterly, so the hours for the levy also will change to quarterly.
Okay. All right. Will workers' access to regulations be continued? So it's referencing, I think, Section 105 regulations applicable to a mine to be displayed at a mine. Is that one of the current regulations, that the regulations need to be accessible at the mine?
Which regulations are we talking about?
It's got 105.
From the Act or from the regulations? Because our regulations are numbered chapter-wise and the particular regulation. We don't number as 105. I don't know.
Not sure.
Not sure.
No, but I mean, the regulations will be available on the legislation website, so yes. legislation.wa.gov.au. So they will be accessible to the public in that way, and everybody can access those or keep a copy of those if they need to keep them handy to refer to.
And WA legislation will have all these documents on their web page as well.
Yes. So they will be accessible. Okay, and we might have time for one more. When we talk about risk management principles, are we referring to ISO 31000?
No, we are not specifically mentioning any ISO standards or an Australian standard in this respect. We have kept away from it. At the same time, the risk management, the industry, the mining industry has to make sure that from very basic risk management, like some companies have Take 5 or job safety analysis, which is done at the front line, to a very complex for a process plant or for operating a complex machinery. So the tools available to make a risk assessment will change, and it is the mine operator who will decide which tool to adopt for a particular risk assessment. But yes, we are not referring to a particular Australian standard, no.
Okay, all right. Well, that's all the questions that we have time for, so I'd like to thank everybody who attended and who provided the questions today, which was a good bunch of questions there. Just a reminder that the webinar has been recorded. It will be available on the WorkSafe website at a future date.